welcome back. We continue with the same section. We were doing about the distribution of the income received by the receiver. First one, he shall deduct the rents, taxes, land revenue, rates and other outgoings. Okay. And second one, he shall deduct the principal, and third one, he shall deduct the interest. Fourth one, he shall deduct the commission. After deducting all this, he shall also give it to any other creditor whom the money is owed to by the mortgagor. After deducting, okay, he can give it to any other creditor to whom the mortgagor owes the amount. Okay, then in payment of his commission and of the premiums of fire, insurance, we read about it, fire, loss or damage. So insurance, in payment of his commission and of the premiums on fire, life and other insurances, if any, properly payable under the mortgage deed. Very important. It should have been mentioned in the mortgage deed or under this act. And the cost of executing necessary or proper repairs. He is going to detect so many things out of this, okay? So, or proper repairs directed in writing by the mortgage. Next we go to the payment of interest and principal money, and then last what shall he do? He will pay the money to any other creditor. After deducting all these things, he will pay this to any other creditor to whom money is owed by the mortgagor. Okay? The provisions of subsection 1 shall apply only if and so far as a contrary intention is not expressed in the mortgage deed. What is given in subsection 1? Mortgagee having the right to power of sale shall appoint a receiver in writing. When the mortgagee, when does he get the power to appoint a receiver? Understand? So he gets a power to appoint a receiver under subsection 1. The provisions of subsection 1 apply only and so far as it is expressed in the mortgage deed. And the provisions of subsection 3 to 8, that is deductions, inclusive may be varied or extended by the mortgage deed. He can appoint the the mortgagee can appoint a receiver only if it is mentioned in subsection 1, as mentioned in subsection 1. That is how? By writing. Subsection 3 to 8 shall apply only if it is there in the mortgage deed or under this act. Okay? Shall. See, this is not an exhaustive list. You should remember that. This is not exhaustive in nature. That means what, apart from this, you may have other expenses also which may be deducted by the receiver from the mortgage money. Whatever amount he has received, other than this, what has been mentioned here, if there are any other expenses, then that can also be deducted. This is not an exhaustive list. Okay? Then application may be made without the institution of suit to the court for its opinion, advice or direction on any present question respecting the management or administration of the mortgaged property, other than questions of difficulty or importance not proper in the opinion court for summary disposal. See, when we are doing the CPC, we have an order as well as a section which speaks about opinions of court, right? Instituting suits for opinions of the court, where the opinion of the court is sought for. This subsection comes under that. So, court for what? Opinion as to management or administration of the mortgaged property. This can be filed like a for an opinion only. So this becomes a summary suit. Am I right? Why? Because we are asking one particular question and it doesn't need anything to go deep into the facts of the case and all that. This is only for the opinion of the court. Understand? So this shall be a summary suit. Unless it is a question regarding the difficulty for management. Understand? A copy of such application shall be served upon and the hearing thereof may be attended by such of the persons interested in the application as the court may think fit. So after the institution of this case, what shall happen? The summons shall be served on the parties. Whichever party is interested in the facts of the case. Okay? Then the cost of every application shall be in the discretion of the court. In this section, court means the jurisdiction in a suit to enforce the mortgage. So wherever the property is situated, we read it in CPC, right? Now with this we end section 69. We go on to section 70. Section 70, accession to mortgage property. We read this yesterday, right? If after the date of a mortgage, an accession is made to the mortgaged property, the mortgagee in the absence of a contract to contrary shall be entitled to such accession. Okay? So what is that accession? Yesterday itself we read. It means addition, anything which is extra, right? So, after the mortgage has ended, after the date of mortgage, that means what? During the subsistence of the mortgage. During the subsistence of the mortgage period. If the mortgage deed has been executed on 25th February 2010, then from 2010 shall be the date of mortgage. Understand? So from this date, any accession has been made, any addition has been made, anything extra occurs, it shall be, unless there is a contract to the contrary. If it is very clearly mentioned in the mortgage debt, mortgagee shall be entitled to only so and so property, and in case of any accession, in case of any accession to the mortgaged property, mortgagee shall not have a right over it. If such a clause is mentioned in the mortgage deed specifically, then the mortgagee will not get a right over the accessed part of the property. Understand? Accession, whatever is the extra part of the mortgage property, that will go to the mortgager. But if it is not written in the mortgage deed, then when there is an accession from the date of mortgage onwards till the end of mortgage, whatever is the addition, everything shall go to the mortgagee. Section 71, renewal of mortgage lease. When the mortgage property is a lease and the mortgager obtains a renewal of the lease, the mortgagee, in the absence of contract to contrary, shall be entitled to the new lease. Yesterday we did it, right? So where there is a mortgage, there cannot be an automatic renewal, right? So what happens? Once the new lease is entered into by the mortgager, the mortgagee shall automatically be entitled to the new lease. Where one lease has expired and a new lease is taken up by between the mortgager and the tenant, the mortgagee automatically gets entitled to the new lease unless there is a contract to the contrary. 72, right of mortgagee in possession. So So what can a mortgagee in possession do? He may spend such money as is necessary for preservation of the mortgage deed from destruction, forfeiture or sale. Okay. So what can the mortgagee do? He may not say, no, this is the mortgager's property. Why should I take care of it? No. Mortgager shall expenditure. He can give the expenditure for preservation of the mortgaged property from destruction, forfeiture or sale. What is forfeiture? When he owes money to some other creditor, that creditor comes and says, give me the property. No. Then the mortgagee can say, no, let the property be with me, but I will give you your money so that you need not take the part of this property which has been mortgaged to me. One property can be mortgaged to many people, am I right? Provided the value of the property is so. Second one, he can provide the expenditure for supporting the mortgager's title to the property. So what we have already seen in the duties of the mortgagee, he should defend the title of the mortgager, right? So here we see that he has the right to give expenses to support the mortgager's title to the mortgaged property. Third one, he has the right to give expenditure for making his own title thereto good against the mortgager. That is what we say suit. Suit for foreclosure, suit for sale, right? So all these suits can be filed, suits for damages, suits for getting the expenses back, suits for recovery of possession, everything is there. Now that is the third one, for making his own title. The mortgagee has the right to spend money for making his own title good as against the mortgager. And the last one, where the mortgaged property is a renewable leasehold for the renewal of the lease. He may also expend money for renewal of the lease which has been given under her, and may, in the absence of contract to the contrary, add such money to the principal money at the rate of interest payable, and where such rate is fixed, not fixed, at the rate of 9% per annum. Whatever are the expenses that he has expended, right? All these shall be added on to the principal amount. And interest shall also be laid on that amount. Understand? Whatever expenses he has taken, he has done, all these expenses can be added to the principal amount, and then the interest shall be decided on that principal amount. Okay, when the principal amount, the interest is decided, then it shall be written. But if no interest rate is decided, then the interest shall be at 9% per annum. Okay, this is what it says. Then we go on to the next one. Where the property is by its nature insurable, the mortgagee may also, in the absence of a contrary, insure and keep insured against loss or damage. Okay, this we have already read. When he appoints a receiver, receiver has the power to collect the insurance amount also, right? He has the power to deduct the insurance amount. So what other right does the mortgagee have? He has the right to insure the mortgaged property. Nothing in this section shall be deemed to authorize the mortgagee to insure when an insurance of the property is kept up by or on behalf of the mortgagor to the amount in which the mortgagee is hereby authorized to insure. Okay, thank you.